I'm glad you're going to get to stay here.
Historic.
I'm glad that I got to throw your ass out here. No, I think it's highly desirable that you people exist and staff people fully informed. I believe in you. I might let you but I'd like to have your judgment, your viewpoint. Seriously. Lord, goddamn. Kiss and say so. Now, as he can just straight. You didn't ask the right question, you just get it.
As far as I know, that's my instruction.
Let's get it.
That's what he told me last night. Was to be his statement, my statement, and he's going to recognize me.
I'm fully prepared on that.
I just stay back for my sporting bench.
We've seen this text or whatever it was at the beginning.
My leader. You want to sit down? What time you gonna get me out of here? I have a 5 o'clock plane.
I know the Sam Garrison.
What time's your plane?
I know the Sam Garrison told me yesterday that he had not seen the whole of it.
Last night. After you talked to him, I saw him just go on that. He's hoping that maybe 4:30. I don't know.
Pass the word.
I told Jim Klein to pass it out to the members of the press.
Dr. Pepper.
But we got nothing to say. It's just a matter of to get with it.
Well, what the hell has that got to do with it? Just because we have nothing to say
No.
doesn't keep us from saying.
We are not going to be eligible to be making a lot of gratuitous comments.
Oh, you're talking the wrong talk. No, he's right. Let me get with these distinguished group here. I might send out a news. You want to get? Yeah, I want you to help. Hell yeah. Virginia General. I drunk it for years. Sorry, no charge. Thank you. Oh, you come get one? Yeah. I don't hurt him. He smokes cigars.
I tried to do right by the committee.
Now, Donnie was running, this boy is running, he's running for his 3rd term.
Thank you, Caller. My pleasure. I autograph him for a small additional fee.
That's my position. I do. You don't.
I'm ready for Rodeo to get started.
Run some more.
Yeah,
Why? Isn't there
they're going to do it to us one more time.
Well, all right. You can run more.
Actually, you're right.
I thought 200 was
listening to the tapes that they want to play on us as they present the evidence. Well, why don't you tell them we're here waiting? Send word that we're going to... They got
Yes, I do. And it's very important that when you conclude, you move the previous question forward.
Morning. Ed, I'm going to recognize you for an opening statement and that, and then we'll recognize Donahue, and then there may be
non-debatable.
You'll move the previous question. Previous question was ordered if there's a vote on the previous question. Majority of those voting, ordering the previous question. Previous question is ordered, and then following that, yeah, but if we move the previous question, it's not a debate.
Is there any objection? Two people not being cleared. One is Lewis operating the machine. This is understandable. The other is a messenger for back and forth. No problem.
No problem. You got all these camera people.
I get on closed session.
I think it's all right.
There's support groups that you need.
I need.
No, it doesn't say defendant. It says if the rule is if it may, then the defendant. But in order to defend, you have to first find out. So you have to consider it. So you consider it in closed session. Otherwise, the purpose of the motion and the rule is defeated.
On that basis, I would think the rule of the thing was non-debatable. I don't think you'd have to argue.
Just period. That's it.
All right.
It's up to Ben cleared it with parliamentarians or whatever they tell you.
Get a newsletter.
I wouldn't
You ready? Catch this here. Thank you, Pete.
I think it's a simple rule that under the rules of the House is non-debatable.
Okay. Listen, I think you better forget about the previous question. Just move it, and I'll say it's not debatable according to the rules of the House. That's all. I just make the motion, and I will state that it's not debatable under the rules of the House.
Should I make the preliminary remarks?
Oh, yeah.
So you'll eliminate the last line.
Right, eliminate the last one.
Then you just say the question is on the motion.
The question is on the motion. If there's an inquiry, I say the motion is not debatable. Hello, Jim.
Hello.
Gary, we're going to write that.
Yeah, we're...
Well, if they want one, they can have one, but it's a waste of time.
Well, we just got through talking. Well, we can talk some more. I don't know how. You know, they must have counted this photograph that you and I talking about.
Not just one man.
We'll use them for something or other.
Man, a record
Look
vote.
at everyone. The rules of procedure provide that the
Principle, most often do it. 20% from the standing.
Yeah,
Okay, I'll tell Mike to get rid of the cameras.
right. Well, wait a minute. You're going to get...
You watch it, and when he drops his hand, then that's time to go live.
Well, I'm going to begin now.
No, just gavel him. They'll...
They want to get a picture of us talking again.
One more.
Hold it up high.
The meeting will come to order. 3 months ago, the House of Representatives considered H-Res 803, and the resolution read as follows. Resolve that the Committee on the Judiciary, acting as a whole or by any subcommittee thereof, appointed by the chairman for the purpose hereof and in accordance with the rules of the committee, is authorized and directed to investigate fully and completely whether sufficient grounds exist for the House of Representatives to exercise its constitutional power to impeach Richard M. Nixon, President of the United States of America. The committee shall report to the House of Representatives such resolutions, articles of impeachment, or other recommendations as it deems proper. The House adopted that resolution by a vote of 410 to 4. We are proceeding under the mandate of that resolution. I don't need to stress again the importance of our undertaking and the wisdom, decency, and principle which we must bring to it. We understand our high constitutional responsibility. We will faithfully live up to it. For some time, we have known that the real security of this nation lies in the integrity of its institutions and the trust and informed confidence of its people. We conduct our deliberations in that spirit. We shall begin our hearings by considering materials relevant to the question of presidential responsibility for the Watergate break-in and its investigation by law enforcement agencies. This is one of 6 areas of our inquiry. We expect to continue our inquiries until each area has been thoroughly examined. First, we will consider detailed information assembled by the staff. This consists of information already on the public record, information developed in executive session by other congressional committees, information furnished by the federal grand jury of the District of Columbia, and other information. After today, the committee will meet regularly 3 days a week for all-day sessions beginning next Tuesday at 9:30 a.m. The chairman will, as circumstances dictate, be ready to notice such business meetings as may become necessary. During the initial presentation, special counsel and minority counsel will explain and summarize the materials. Our proceedings are governed by the rules of confidentiality that the committee adopted on February 22nd and the rules of procedure adopted May 2nd. The committee has the power to modify or change these rules during the course of these hearings. Some of the materials which the committee will consider have been held confidential by the staff, by Mr. Hutchinson and myself. This material includes tape recordings of conversations among President Nixon and his key associates. We will listen to these recordings during these hearings. After the Judiciary Committee has had the opportunity to consider this material, it will decide if and when, in the national interest, this material should be made public. The Judiciary Committee has determined that President Nixon should be accorded the opportunity to have his counsel present throughout the proceedings. Mr. James St. Clair is present today. After the initial proceedings are completed, Mr. St. Clair will be afforded the opportunity to respond to the presentation orally or in writing as determined by the committee. He and his assistant understand the committee's rules of procedure and the committee's rules of confidentiality, and they are bound by those rules. Our proceedings will be conducted under the rules of the House of Representatives. Technical rules of evidence do not apply. We are governed by the Constitution of the United States, which vests the sole power of impeachment in the House. A brief report of the day's proceedings will be issued at the end of each day's hearings. And I recognize the gentleman from Michigan, Mr. Hutchinson.
Thank you, Mr. Chairman. Today, the committee starts consideration of the most awesome power constitutionally vested in the House of Representatives. During the past 4 months, this committee's impeachment inquiry staff has been assembling information under the committee's direction, and counsel will now present to the committee the information assembled. The power of impeachment is one of those great checks and balances written in our Constitution to ameliorate the stark doctrine of the separation of powers. But impeachment of a president is most drastic, for it can bring down an administration of the government. The Constitution itself limits the scope of impeachment of a president to treason, bribery, or other high crimes and misdemeanors. A law dictionary published in London in 1776 defines impeachment as, and I quote, the accusation and prosecution of a person for treason or other crimes and misdemeanors. Any member of the House of Commons may not only impeach any of their own body, but also any Lord of Parliament. And thereupon articles are exhibited on behalf of the Commons, and managers appointed to make good their charge and accusation, which being done in the proper judicature, sentence is passed. And it is observed that the same evidence is required in an impeachment in Parliament as in the ordinary courts of justice, unquote. That definition of the term fairly exhibits, I believe, the understanding and meaning of the founders of this republic when they wrote into our Constitution the sole power of this House to impeach the President of the United States. The standard it imposes is a finding of criminal culpability on the part of the President himself, measured according to criminal law. I trust that the members of this committee embark upon their awesome task, each in his own resolve, to lay aside ordinary political considerations and to weigh the evidence according to the law. I trust that each of us is resolved during this inquiry, schooled, skilled, and practiced in the law, as each of us is, to perform as a lawyer in the finest traditions of the profession. And in view of the enormity of the responsibility cast upon us, I trust that in the days and weeks ahead, each of us will, according to the dictates of his own conscience, seek the guidance of that divine providence which can be with us all and be everywhere for good, and which has so blessed this nation and its people throughout our history.
I recognize the gentleman from Massachusetts, Mr. Donohue.
Mr. Chairman, as I understand it, the impeachment inquiry staff has received a wide variety of material, which has, up until now, been the subject to the requirement of confidentiality. Included in this class of confidential material are documents which have been received from the grand jury, as well as materials developed by other congressional committees in executive sessions. Under the circumstances, Mr. Chairman, it is my opinion we should not make all of this material public today. Therefore, I move you that during this initial phase of the presentation, the committee go into executive session pursuant to Rule 11, Clause 27 of our House Rules. That rule provides that if evidence or testimony at an investigative hearing may tend to defame, degrade, or incriminate any person, the committee shall receive such evidence or testimony in executive session. I second the motion.
Motion has been made and seconded. The motion, I might advise the gentleman from Michigan, is not a debatable motion.
Executive session.
The question is on the motion, since the question is not one that is debatable. And the chair will put the question to the committee. All those in favor?
Point of order. Mr. Chairman,
The
I raise
gentleman
a
will
point
state
of
his
order.
point of order.
Is the chair suggesting that a motion of this importance and magnitude, with no more than being stated and seconded, cannot be considered by the members of this committee gathered here for the purposes of an impeachment hearing?
Is the gentleman stating a point of order, or is he inquiring of the chair? The chair has already ruled that this motion is not a debatable one in accordance with the rules of the House, Rule 11, 27M. And therefore, unless the gentleman is ready to state that he has an argument to support his point of order, the chair is ready to present the question on the motion.
Roll call, Mr. Chairman.
Ask for a roll call vote, Mr. Chairman.
The lady will state the parliamentary inquiry.
I understand the gentleman's motion to be to close the hearings or receive the testimony in the executive session for the first phase or for only this meeting, this hearing session?
For the initial phase of the hearing.
Thank you, Chairman.
Mr. Chairman, a point of order. As I understand the House rules, we must vote at each session of the committee whether that committee shall be open or closed. Is that correct? Therefore, we are really only voting on this day's session.
This, as the chair will again state, that the session that would be closed, of course, would relate to today. And at any subsequent time, the chair could entertain another motion. But the motion that is put to the chair at this time is a motion to close this hearing in order that we hear this initial presentation in accordance with Rule 1127M, which suggests that where there is the possibility that any information may tend to degrade or defame, that the session be an executive session. And therefore...
Well, Mr. Chairman, if I may pursue this inquiry just a little bit, it's my intention to support the motion. However, it's my understanding of the rules that at the next session of this committee, if it's to be a closed session, a similar motion will have to be made and approved. And at each subsequent session, which is desired to be closed.
The question that the gentleman is propounding suggests that we will be continuing, and we are going to be continuing this hearing. We will be recessing from time to time.
But each day, I mean, at each day's session, at the start of each day, a similar motion must be approved, as I understand the rules.
Mr. Chairman, parliamentary inquiry.
The gentleman will state it.
Is it not the rule of the House that we are bound by, and that we don't need any motion or we don't need any action by this committee? All we have to do is comply with the rules of the House, which is what the chairman is suggesting, and the action that we're taking at the present time.
The gentleman is absolutely correct. We'll recognize the gentleman from New York for a parliamentary inquiry.
Mr. Chairman, under this motion of the requirements of confidentiality, does the staff of the President of the United States who are now present, are they governed by these rules?
The chair has already stated that the counsel for the President and his assistant are governed by the rules of confidentiality and the rules of procedure.
Parliamentary inquiry, Mr. Chairman. Mr. Chairman, parliamentary inquiry.
The gentleman will state his parliamentary inquiry.
Mr. Chairman, do I understand, since there's no access on the part of the committee to the materials, do I understand that the chair is representing to the committee that these materials do, in fact, tend to degrade and defame?
The chair is stating that, in accordance with the rules, all that has to be suggested in the motion is that they may tend to defame or degrade, and not that there is a finding of fact.
I ask if the chair is suggesting that the materials may tend to degrade and defame.
The chair is merely acting on the motion of the gentleman from Massachusetts.
Then may I make a parliamentary inquiry to the gentleman from Massachusetts? Will the gentleman from Massachusetts tell me?
The parliamentary inquiry will not be directed to anyone else but the chair, and the gentleman recognizes that. However, I would state to the gentleman that the gentleman has already been told that this is the rule and that there is no need that there be a finding in fact. Therefore, the gentleman's inquiry is out of order. And the chair now puts the question to the roll call vote is demanded. However, in accordance with the rules of the House, 1/5 of the members would have to support a request for a roll call. All those in favor of asking for a roll call by record vote, please raise their hands. 1/5 of the members, a sufficient number, has voted in the affirmative, and a roll call is demanded, and the clerk will call the roll. All those in favor of closing the hearings, please say aye. All those opposed, no.
Aye.
Mr. Brooks.
Aye.
Mr. Kastenmeier. Aye. Mr. Edwards. Aye. Mr. Hungate. Aye. Mr. Conyer. No. Mr. Eilberg. No. Mr. Walde. No. Mr. Flower. Mr. Mann. Aye. Mr. Sarbanes. Aye. Mr. Seiberling. Aye. Mr. Danielson. Aye. Mr. Dryman. No. Mr. Rangel. No. Miss Jordan. Aye. Mr. Thornton. Aye. Miss Holtzman.
No.
Mr. Owens.
Aye.
Mr. Mezvinsky.
Aye.
Mr. Hutchinson.
Aye.
Mr. McClory.
Aye.
Mr. Smith.
Aye.
Mr. Sandman.
Aye.
Mr. Railsback.
Aye.
Mr. Wiggins.
Aye.
Mr. Dennis.
Aye.
Mr. Fish.
Aye.
Mr. Maine.
Aye.
Mr. Hogan.
Aye.
Mr. Butler.
Aye.
Mr. Cohen.
Aye.
Mr. Lott.
Aye.
Mr. Froelich.
Aye.
Mr. Moorhead.
Aye.
Mr. Mariziti.
Aye.
Mr. Levin.
Aye.
Mr. Rodino.
Aye.
Mr. Chairman, 31
To vote.
31 members have voted aye, 6 have voted no.
And the motion is agreed to. And the chair will now announce that the committee will go into recess until the television cameras and other equipment, which is not allowed during the, and persons not permitted during the course of confidential hearings, will be removed from the room. I think I left it really. But I think that we would take the
In order to get this thing going, the chair was going to rule that the consensus is all one session.
Mr. Hogan has asked that you leave. And Sam will handle the executive session. I'm doing that now.
I just wanted to occur for history that I was up there.
Now back to Chicago with a regular pursuit. Well, Sam? Well, I don't know. I haven't gotten any feedback from the White House. What are you doing? You didn't use me.
Henry will have to leave. One of us called a practice.
Okay, got it. Which makes her enormous hindrance. That's right, he doesn't let the impeachment fail. Mr. Connors is being
Do you have any estimate of how long they will be on for his presentation?
No, then you'll have to go into journalism.
Electrician, restore the lights.
The blue book that I see in front of me, Constitutional Working Book, in other words, that is out of sight of me. Like that.